Now I am going to dictate a legal passage at the rate of 120 words per minute based on latest Supreme Court judgment. Let's start. There is no postal receipt and the tracking report in the records about which the family court has referred to in the proceedings of the divorce suit. In the judgment in the divorce suit also, there is no reference of any postal receipt or tracking report which was duly removed and marked as exhibit in the trial. Therefore, there is no material available on record to support the order dated 15th February 2021 by which the divorce suit was set for ex parte hearing against the appellant on the ground that she had been duly served the summons parachange. The plea taken by the respondent in the present first appeal that the appellant has notice of institution of the divorce suit in as much as she herself filed transfer petition within bracket civil number 16 of 2020 cannot be the reason to lend support to the ex parte judgment in the divorce suit. The judgment raised on behalf of the respondent appears to be based on proviso to Order 9, Rule 13 of the Code of Civil Procedure, which provides that no party can be permitted to challenge an ex parte order on the ground of irregularity in service of summons in which she had knowledge about the date of hearing and had sufficient time to appear and answer the petitioner's claim. However, the filing of the transfer petition was not pleaded before the family court in the proceedings of the divorce suit, and while so the ex parte judgment in the divorce suit cannot be supported in law by raising a plea that the appellant had knowledge about pendency of the divorce suit. Moreover, mere knowledge of pendency of the suit is not sufficient to apply the restriction under second proviso to Order 9, Rule 13 of the Code of Civil Procedure. Rather, it must be pleaded and proved that the other party had a knowledge of the date of hearing and sufficient time to appear before the court to answer the plaintiff's claim. These facts are not established by the respondent even in the present proceeding. Stop para. The second ground of challenge to the ex parte judgment in the divorce suit is that the materials laid by the respondent during the trial of the divorce suit do not establish desertion by the appellant as claimed by the respondent. In our opinion, this is a substantial ground to interfere with the judgment in the divorce suit. We may indicate here that even after the aggrieved party is not successful in his or her attempt in getting the ex parte order judgment set aside by an application under Order 9, Rule 13 of the Code of Civil Procedure, he or she still can prefer first appeal under Section 96 of the Code of Civil Procedure to challenge the order of judgment on merits. Therefore, in this first appeal, the judgment and decree in the divorce suit can be examined and on being satisfied can be set aside by this court in exercise of powers under Section 19 within bracket 1 of the Family Courts Act, which is undoubtedly akin to Section 96 of the Code of Civil Procedure para. In our opinion, the ex parte judgment in the divorce suit is flawed for more than one reason. There was no proper service of summons upon the appellant, and even assuming that she had knowledge of the divorce suit within bracket, though this fact was not pleaded before the family court, the ex parte judgment against the appellant is liable to be set aside on merits para. In view of the aforesaid discussions, the judgment dated 26 March 2021 passed by the learned Principal Judge Family Court Ranchi in original suit number 230 of 2020 is set aside, and accordingly first appeal number 30 of 2001 is allowed. Stop. Thank you.